Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And I have a question for you all. XRP has been going insane, but do you expect XRP to hit a new all-time high in 2021, or do you think it's going to take some additional time? Let me know in the comment section down below. Today, we're going to be covering the Ripple v. SEC lawsuit. I thought I could get into it in the previous episode, but we didn't really have time, so today we are covering everything that has happened over the last couple of days. Starting it off by looking at James Fillon's Twitter, because, well, that's where the majority of us get our stuff from, our juice, so to speak. First of all, let's quickly check it out. SEC filed emergency motion for a discovery conference regarding Slack communications. This came out on August 9th, and they basically sought an order compelling Ripple to search and produce relevant communications between Ripple employees on Slack. So, long story short, Ripple was communicating on Slack. The SEC is now saying, hey, we requested that info. You first were willing to give it, then denied it, but now it's a little bit confusing. Just give us a limited version of all of that info. And Ripple is saying, nope, screw you. We don't want to give it to you because you don't deserve it. Something along those lines. Then, breaking. Parties tee up deliberative process privilege dispute with respect to documents withheld by the SEC based on the SEC's assertion of the privilege. File joint request for age-paid letters addressing the issue. So, once more, this is just a request, basically, that they want to get a discussion going. This is just Ripple, I believe, who wanted to say, hey, we want to get a discussion going regarding your privilege. A little bit later, we get that Ripple filed request for extension of time until Monday, August 16th, to respond to the SEC's emergency motion regarding the Slack communication. So, of course, whenever they put up a motion like this, an emergency motion specifically, there's a timeline for things. And especially right now, because we're getting closer and closer to the end, the deadline date was rather soon, but they basically asked 2 more business days to respond to it, instead of Thursday, August 12th to Monday, August 16th. A little bit later, let's quickly check it out right here. The motion to file X's pages was granted. Judge Netburn says the parties' letter briefing shall not exceed 8 pages each, though the court strongly encourages the defendants to jointly file a single 15-page letter if possible. So although Ripple, Brad Garlinghouse, and Chris Larsen could each file a separate 8-page letter, Judge Netburn wants them to file a single 15-page letter addressing all of the claims in that one. So that's actually to do with this letter that just came out on the 9th as well. In it, they basically said, hey, 2 things, right? I believe it's this one. It might be the other one from the SEC side. It doesn't really matter too much, honestly. They basically said, hey, we want to get a little bit of extension of time, and we want to actually make sure that we get 8 pages per letter. She basically said, yeah, that's fine, but Brad Garlinghouse and Chris Larsen, if you're going to file something, make sure that you two, I believe, right? Yeah, you two, don't file 8 and 8, but file 1 of 15 pages, because a lot of the information is overlapping, and she likes it to be in one letter because the majority of the stuff is the same anyway. Then the next day, or I guess it's the same day already because I skipped a little bit, Judge Netburn grants Ripple's motion for extension of time. She orders that Ripple responds to the SEC's motion is due no later than August 16th. The SEC's reply, if any, is due no later than August 19th. So here we got the schedule, right? Ripple can respond basically to this initial proposal that they have to give over their Slack communications, and they have to about August 16th for that. And then the SEC can respond yet again, and they have to about August 19th for that. Then we have another piece, breaking. Defendants file motion challenging the SEC's improper assertion of deliberative process privilege. And this is basically a V2.0 because, well, even though they filed something, let's quickly check it out right here, this is basically just the request to get a discussion going. And you can also see again about the 8-page letter thing. They basically just filed a request to get this discussion going about, the deliberative process privilege, which has to do with what information the SEC can keep for themselves. And here is the first time where they basically are putting up, once more, Ripple, a letter explaining how the deliberative process privilege really does not apply right here. And we can actually open that up to talk a little bit more in depth about it in just a second. But once more, Ripple is opening up the stage, the SEC is going to respond, and then Ripple is going to reply to it once more. And then the judge obviously is going to make her decision if it is necessary. Most likely it is. Then, here's another thing which happened, or at least, actually, there was this letter which just came out about Ripple, which we just read. There was a discussion below that. XRP Yadman said, I'm curious as to why Judge Netburn has not done anything about the SEC not turning over documents that were ordered to be turned over by her. This seems fishy to me. Does she herself, Judge Netburn, have an agenda that we, the people, don't know of? Function Maxi said, I have yet to hear a reply as to why she has allowed this. If it was Ripple refusing to provide twice court-ordered documents, then she would have sent in the feds to force them by now. It's because SEC are a government agency, so judges give them special extrajudicial privilege. And, well, the short answer is that judge ordered documents produced, subject to a privilege assertion, and said documents withheld on the basis of privilege must be identified on a privilege log. The SEC submitted privilege logs claiming everything is privileged. And Ripple now is calling BS. So, my own long story short version is, well, even though Ripple is supposed to get all the information, the SEC claims that all the information which they're supposed to hand over is privileged. And so right now they're figuring out this what exactly is privileged issue. That's mostly so what the deliberative process privilege has to do with. So they're figuring it out, so to speak. All right, moving on because we have more. Then we got Ripple SEC. Gary Gensler says certain rules related to crypto assets are well settled. The test to determine whether a crypto asset is a security is clear. The SEC has taken and will continue to take our authorities as far as they go. Remote that with, oh wait, let's see, there's more, because I see one thing is missing. A typical trading platform has more than 50 tokens on it. This is a quote from Gary Gensler. In fact, many have well in excess of 100 tokens, and while each token's legal status depends on its own facts and circumstances, the probability is quite remote that with 50 or 100 tokens, any given platform has zero securities. It should now be clear that Gary Gensler, that's the end of the quote, it should now be clear that Gary Gensler wants to rule over the entire crypto asset space. Thanks Ron W. Hammond for providing the Gary Gensler response to Senator Warren. Gensler also said, we haven't yet lost a case. Interesting. I read the entire speech for you guys who went over it, and it definitely from some perspective looks like a power grab from Gary Gensler, which is not that juicy. Then again, it's the way that things go in this space, right? Bureaucracy. Then, 5 hours ago, Patrick McHenry, statement by Representative Patrick McHenry, the top Republican on the House Financial Services Committee, said, Chairman Gensler's latest move to ask Congress for jurisdiction over non-securities exchanges is a blatant power grab that will hurt American innovation, said Republican leader McHenry. Given the distinct nature of digital assets, policymakers must be thoughtful and deliberative in legislating in this space. That's why I introduced H.R. 1602, the Eliminate Barriers to Innovation Act, to bring regulatory certainty to market participants and regulators. We need smart policy made through a transparent process to ensure innovation and job creation continue in the United States. We don't need another backroom deal between Gensler and Elizabeth Warren, which is a rather interesting little quote. Then, a little bit later, more came out. Brad Garlinghouse filed a motion to seal exhibits, including parts of William Hinman deposition's transcript as part of the deliberative process privilege dispute. So, once more, to kind of further this dispute about the deliberative process privilege, Brad Garlinghouse, or basically Ripple's side, put up a letter in which they basically explained some of the stuff which they're filing is sealed behind closed doors, and that the SEC has to confirm that by writing a letter saying they want it to be sealed. At least, that's as far as I've gotten now, but there could be some discrepancies what exactly this means. It's not that important. Some stuff is hidden in this motion right now because they're figuring out an issue over what stuff should be hidden. To file something under seal basically means something is hidden and not for the public, and the deliberative process privilege is just stuff basically that in this entire process cannot really be used or has to be behind closed doors as well. It's privilege, it's not usable. Judge Netburn grants the letter motion to seal. So it basically can be sealed behind closed doors for the public. Quote, the documents may be filed under seal on an interim basis, subject to further reconsideration by the court when it considers the merits of the underlying motion, end quote. So that basically means, well, we'll just make sure it's not available to the public by now until we think it needs to be public. Then 6 hours ago, because a lot of stuff happened over the last 2 or so days, the SEC has requested 2 additional days until Tuesday, August 17th to submit a motion to seal the exhibits filed with Ripple's letter challenging the SEC's improper assertion of deliberative process privilege. So once more, to kind of go on this issue that we just expressed, they wanted some extension of time. And right now the timeline, as you can see right here, Judge Netburn grants letter motion for extension of time. The SEC's deadline to file a motion to seal, if any, with respect to the exhibits filed with defendants August 10th letter motion is extended to Tuesday, August 17th. So they have a couple of days to actually make sure that that stuff is sealed if they want that. Then a little bit later, that Ripple has requested 2 additional days until Monday, August 16th as well to submit a motion to seal the exhibits filed with the SEC's motion to compel the turnover of relevant Slack communications between Ripple employees. So once more, if you want a summary, the 2 issues at hand have now been requested to be sealed, and they basically requested some extra time for all of it. Judge Netburn grants letter motion for extension of time. The deadline for defendants Ripple to file a motion to seal, if any, with respect to the exhibits filed with the SEC's August 9th letter motion is extended to Monday, August 16th. So, long story short, everything has been extended. Most things actually, are done behind closed doors now in this specific regard, and we have no real big update, except, I guess, for this letter, which was quite interesting, about why Ripple thinks something, right? Let's check it out. We write on behalf of Ripple Labs and all those other guys to address the SEC's improper assertions of privilege, principally deliberative process privilege over relevant communications or documents that it has been twice ordered to produce and that are vital to the defense of this case. So this specifically here is about every piece of information that the SEC has been withholding, as they basically claim that it's in their right to not give this information out. Here's a list of basically what stuff they're trying to hide as well. One interesting thing is, again, about the 63 emails attaching drafts of Mr. Hinman's speech, each of which is asserted to be protected by both DPP and the attorney-client privilege, and each of which is described as an yada yada yada. So that's about the privilege log. So if you want to know what the privilege log is, the SEC put up multiple different privilege logs to explain what documents in what specific area should not be given over because, once more, they're privileged. Ripple's now trying to question that, saying, no, we don't really think so. And a good part as to why I think Ripple will actually win on a couple of grounds here is because the SEC is withholding so much information. If you look through their requests and words, basically, they're withholding so much information that any judge is going to notice, yeah, you can't hide all of that. I mean, you can hide some stuff, definitely so. You can claim some stuff as privileged, but not everything. And specifically regarding the emails attaching drafts of Mr. Hinman's speech, that one is going to be a really difficult one because, theoretically speaking, the entire draft of Mr. Hinman's speech is in no way, shape, or form privileged at all anyway. You might say that the email attachment, it being, is a privileged thing, okay, but the draft itself shouldn't actually be, for my own personal reasons. Why? Well, if you think about it from a certain perspective, I'll explain that to you. The SEC has a couple of high-ranking members, right? Like, for example, William Hinman. Okay. He's not working there anymore. Important key detail, but all right. Even though he was working there, he did put up a letter with his own opinion. If Trump goes somewhere and goes to talk about just things that he wants in his own opinion, not as the United States president, which he's not anymore, but you guys get the picture, or Biden right now, but just because he is, Biden, or Trump because he's Trump, he just talks about his opinion about things, that can definitely be used against him in court. Because he's still a human being. Even though he's a high-ranking official, if he does something that's just out of his own name, it's not all of a sudden as if they're above the law, right? No, just on some stuff. If he's acting as the president of the United States, he should not be held accountable for some of the words he makes because that's, basically the freedom that you have as a high-ranking member of the public. Or of the government, I guess. That you should be able to tell whatever the frick you want without any dire consequences, as long as it's within margin. I mean, if he's saying something really, really crazy, sometimes it's going to hurt him, but he can't really be sued for it too much. He can just basically be arrested, for example, for some of the you guys get the picture I'm trying to paint here. Then again, the same thing goes for William Hinman. If he says something officially as an SEC opinion, he shouldn't be held accountable. I understand, I accept. If he says something in his own opinion, though, he should be able to be held accountable. Not necessarily indicted for it, but he should be able to be questioned about it at least. And what I mean with that is that Well, right now, the SEC is claiming that William Hinman made his speech on his own and he did not reflect any SEC opinion, but when he gave the speech, the SEC did look through all his drafts of the speech he was going to give. They did approve it as well, and so they did give, because there went some internal communications, obviously, they did give their seal of approval. They did say, hey, this is okay to talk about because, well, the SEC has to approve all that stuff inside and it has to kind of go along with the SEC's internal morals and motives. I'm not sure. Yet, in the end, once we then, explain that, okay, was it an SEC-inspired type of speech? Was it an SEC opinion? They say no. Yet, if it's only William Hinman's speech, then it should be, just not privileged. They say no, it should because he's an SEC official. But then again, he's not acting as one. And even if he was back then, he is not now. So, and that issue kind of comes at hand here that I think will eventually be fixed. And I think the judge will side on Ripple on that part. But that's all stuff, right? Let's go to the four-ish main points. 3, 4. The SEC should not be permitted to withhold relevant and potentially exculpatory evidence on the basis of deliberative process privilege. What they're saying is, once more, they shouldn't be able to hold all of this because it's key to the case. Then, because I want to keep it kind of short, the SEC has failed to properly invoke deliberative process privilege as to the documents it is withholding. So they're saying it's privileged, yet they can't really prove that it should be privileged, which is stupid. And then let's quickly see number 3. The SEC's alternative basis for withholding policy-related documents fail, so what they are trying to say doesn't actually work in the real world. Finally, the SEC asserts attorney-client privilege and that the attorney work product doctrine as an alternative basis for withholding certain law documents. The SEC's invocation of these doctrines appears substantially overbroad, and the SEC should be required to further substantiate its claims of privilege. That's what they're basically saying. And then the conclusion down below here. Defendants respectfully request that the court find that the SEC may not invoke DPP with respect to the narrow categories of document covered by the court's April 6th and May 6th orders, and therefore compel the SEC to produce these documents responsive to its April 6th and May 6th orders that are withheld on the basis of DPP. In the alternative, the court should require the SEC to produce the withheld material for in-camera review of its privilege claims. To facilitate the court's review if necessary, defendants have prepared Appendix A, which reflects a sample subset of documents that appear most likely to bear on the claims and defenses in this case. And I believe Appendix A might have also been sealed. Yeah. So they basically filed this under seal preemptively. How do you say it? Like, they filed it within seal just in case. And they basically, the judge later ruled, said, yeah, this is fine to put under seal. And about some other part about the conclusion, let's quickly see. This part about the in-camera review, the judge also said that is also, no, I'm not sure if she said that's fine. She basically had no, guys, I don't remember now. Maybe it was the SEC who had a question about why they wanted this in-camera review about something. They brought it up, but I kind of forgot exactly where it was. But hopefully you guys by now have a little bit better of an understanding about what is going on in space right now. It's a back and forth about these two issues. 1, Ripple holding information back from the SEC, and 2, the SEC holding information back from Ripple. Ripple's doing that in the form of Slack communications. Slack is basically an app, like a kind of like email, but then a little bit more of an app type of system. And the SEC is doing it in just saying everything is privileged and hiding it, basically. So yeah, so it's gonna be an interesting dispute. I think Ripple will mostly win everything that's going on right now. Everything being sealed, however, is just the way that lawsuits sometimes work. Things need to happen behind closed doors because, well, William Hinman, for example, has been deposed. He has been questioned, and most likely a lot of questions that he has answered are out there for Ripple to see, but not for the public, because they might not be able to use it in court just quite yet until the judge gives the order for it, which that type of stuff is right now being figured out. And yeah, we shall see. Guys, if you enjoyed this video, make sure you press the like button. If you also want to trade crypto, make sure you check out Bybit. A link is down below. And I'll definitely see you guys again in another crypto video later today.